Hey everybody, welcome to Webinar Wednesday. I'm Jonah, and I'm going to be joined here today by Andrew McRoberts from Sands Anderson. Of course, today we're going to be talking about vested rights law and how that has been going here in Virginia. I'm the director of the Land Use Education Program, which provides land use education to planning commissioners, BZA members, and interested members of the Commonwealth. LUEP is a partnership between Virginia Cooperative Extension and the Center for Public Administration and Policy with Virginia Tech. Like I said, we're going to be talking about vested rights today. We've got Andrew. Let me give you a picture of Andrew. There he is. Say hi, Andrew.
Hi there.
I'll get more background on Andrew here in a minute, and he'll have a chance to explain himself. But I did want to make sure people were comfortable with the format. We're sort of experimenting here a little bit with the idea of webinars. So we're getting comfortable with technology, and hopefully you guys are interested in providing us some feedback as we go along. For those of you who are joining us online, you'll notice that there's a chat box off to the right-hand side of the broadcast. And if you'd like to pose a question or a comment to Andrew or myself, you're welcome to do so. All you need to do is log into Google, and you'll be able to post some questions and comments there for us as we go along. Andrew can see what you're doing, so if you have a comment, Andrew might stop along the way to address what you're talking about. Otherwise, we'll save questions to the end. I know we'll have a PowerPoint presentation and plenty of time for questions and answers. I think we'll have about a 40-minute presentation with time after that. Also in the chat box already, you'll probably see that there's a URL, there's a link there for anybody who participates in the webinar today or views the webinar after the case. After the broadcast, you'll see a link there for the evaluation. If you do have some time and you can provide us some feedback about what we're doing, also maybe some future topics that you'd like to see, click that link and let us know, okay, so we can do a better job for you all. Andrew McRoberts is with Sands Anderson. Of course, we're doing this webinar in partnership with him and Sands Anderson. We're also partnering with the American Planning Association Virginia chapter, who's graciously providing one continuing management credit. So if you're interested in getting a little AICP credit, we're going to be making sure that's available for you, and hopefully we'll have some more information about that soon. Andrew McRoberts is a shareholder at Sands Anderson. He heads up their government group. He has many, many years of experience as a county attorney around the Commonwealth. I counted at least 7 localities from his biography that he's represented over the years, and has been party to some of the very interesting land use cases that have gone up into the Virginia Supreme Court. He teaches with us regularly. We've had him speak both at our Certified Planning Commissioner program, but also Board of Zoning Appeals program, and many of our conferences. So we're always pleased to have him with us. He's the 2012 Edward J. Finnegan Award winner from the Local Government Attorneys Association. It's their highest award, and he's also served as their president. So he comes with certain accolades up and down the block. And if that makes him a bit of a Boy Scout, there's a reason for that. You'll notice that in his biography, if you take a look at his Sands Anderson page, that he actually was a Scoutmaster. He isn't currently, but he's had many, many years of enjoying the company of other Boy Scouts. So he's a real stand-up guy, and we're always pleased to see him. Andrew, I know you've got some PowerPoint slides to share with us, and a great deal of experience too. We're going to be talking about vested rights. Can you maybe start off by just giving us a little bit of a definition about where this fits into law in Virginia? Okay,
can you hear me?
Yeah, you sound great.
Okay. Well, I'll start with the presentation, and I think that's kind of going to go into all of that. The bottom line is we're talking about vested rights in zoning, the law of zoning and land use, and vested rights is one of the very few exceptions to the current law, and so I think it's important to take a look at that. You ready to start?
Absolutely, yeah.
Okay. Let's see. All right, can you see that?
You're all set, and just let me know if you need anything, but otherwise I think you're in control.
Okay, great. I will tell you in advance that I have 130 some slides that I can't possibly cover in 40 minutes. So I will be skipping through a lot of this stuff. Obviously, a lot of this is historical. This is intended to be sort of a comprehensive report on the law of vested rights in Virginia from its beginning to, what's going on right now. I can't possibly cover all of that in 40 minutes. But rather than water down the slides, I really thought that presenting all of them and just simply telling you sort of in summary some of them would be more helpful. There's my contact information. You can certainly Google Andrew McRoberts or McRoberts and Sands Anderson, and you can get in touch with me if you need to. Like Jonas said, I mean, we do local government law all over the state, and we love working with localities and defending them in these kinds of cases. So be glad to hear from you if you have any questions at all about these kinds of things. Introduction. A vested right is a land use and is a property right, which is created and protected by law. That's Holland versus Johnson, a Supreme Court case from 1991. You see below that in a much smaller font. And those rights are also strictly limited by that same law. That's a quote of me. I just said it. All right, the ABCs, 3 key legal points from common law as a background. So before we get to the law of vested rights, what are 3 common law legal principles that actually intertwine through the law of vested rights? You'll hear these points time and time again as I discuss the cases a little bit later on. So the ABCs, what is the first one? Apply the law. Bottom line is privately held land is subject to the applicable zoning ordinance, no matter when it was adopted, before or after the property was acquired. Even if the property owner had an expectation or an anticipated use of their property, that does not change the law. I know that my fellow county and city and town attorneys see this all the time. Well, but they've owned it a long time. They really thought that they wanted to do this. Does that change in the law apply? Yes, it does. Rule number 1. Second one, even before the statutory vested right standard, there was common law. In limited circumstance, private landowners may acquire a vested right in planned uses of their land that may not be prohibited and reduced by subsequent legislation. And really what we're going to talk about today is what are those limited circumstances? And I think it's significant that landowners don't have a right to a vested right. They bear the burden to prove it by clear, express, and unambiguous evidence. And so the B is, but exceptions to the law can be created by the developer and the government in limited circumstances. And the third point of common law that is applied is a zoning administrator cannot vest rights contrary to the zoning ordinance. Gwynn versus Alward applied and said estoppel doesn't apply to the government in the discharge of their governmental functions. And despite years passing with multiple governmental approvals and whatnot of the facts of that case, the local government was not estopped, but the landowner was barred from attacking the zoning administrator's determination because it didn't apply within 30 days. The bottom line is we'll talk about this principle a lot today because it's one of the most popular ones from the developer community, that you cannot rewrite the law if you are an administrator. For well over 40 years, the Virginia courts have addressed those limited circumstances, and the courts have rarely found that those limited circumstances apply. I'm not going to talk a lot about this next section. From 1972 at the Supreme Court's very first vested rights cases, medical structures, and city service, through 1998 of sort of codification of the vested rights standard in the Virginia Code 15.2-2307. There's a number of cases. I'm not really going to go over them, in part because it really gets codified in 2307. The General Assembly created a few more. There's medical structures. In 1990, there was an amendment that created quill investing, which we'll address a little bit later on about conditional zoning. The Russell case, the Holland case, a few others here.
Andrew?
Yes, sir.
Just very quickly, I have a question from Doug Hansen. He's wondering what does it mean when you say estoppel?
Okay, that's a very good question, and I apologize for speeding through that topic. Estoppel is really a common law principle that says that if you have acted in reliance upon a representation or action of someone else to your detriment, that actually creates the consideration for essentially a contract between the person that made the representation and the person that acted in reliance. And that contract bars them from changing their action or their position on which there was reliance. In other words, that contract bars the person from changing their position or their action, okay? But because that common law principle is a contract principle and a common law principle, it does not apply to governmental actions, which simply governments can only act as they're authorized to act and only within the authority to do so. So, so the general principle is estoppel is basically being barred from changing your position because of a contract that's been implicitly created, but that can't be done in Virginia governments because governments can only act as authorized by law and not outside of it, and they can't be stopped to change the law. So that's it. So good question. Okay. Basically, before 1998, 15.2-2307 existed, but all it really said is vested rights are protected, but they didn't define what those were. And so in 1998, the statute did that. There was a number of other amendments through the years. What they essentially did in adopting the statutory standard is they adopted all of the current law with some changes. They actually reversed a couple of earlier Supreme Court cases that had said things like, for example, variances are not significant affirmative governmental approvals that are required for vested rights. Preliminary site plan approvals, for example, are not a significant affirmative governmental approval. So they changed those things to allow it. They also introduced some new terms that had never really been used before then. I need to postpone this. Specify use, specific density, specific project. They didn't have a statutory definition, and so the General Assembly left them for the courts to define. They expanded vested rights as determined by the Supreme Court by defining 6 acts, which were significant affirmative governmental acts. In order to have a vested right by common law and now by statute, you had to have one of these things. And then that was the act on which there was reliance, on which there were substantial sums spent. And if you did all of those things and you showed all of that by clear evidence, then you could achieve a vested right. Well, this statute defined those things, and then the 6 things are there. Some of them were significant affirmative governmental acts, or as I call them sometimes here, sagas, that were in the statute originally. I'm going to skip ahead a little bit because we do want to get to sort of the meat of the presentation. In 1995, there was a significant amendment too that amended then 15.2-2311 and its predecessor 15.1 to add a subsection C. And that actually also, in addition to the vested rights principle in 2307 that was adopted, about a few years later, in 1995, they amended the code to say that the zoning administrator could be stopped in limited circumstances to vest rights in a zoning ordinance use that would otherwise be impermissible. And that there really were no Supreme Court cases for a really long time in 2008 on that principle. And we'll talk about that principle today because that is one of the most popular areas of litigation these days because often there is a zoning administrator saying you can't do this, and understandably folks want to get around what the zoning administrator has said to them at times, and sometimes they want to get around the text of the ordinance itself, and we'll talk about that. 2311C I'll talk about first for 2 reasons. One is it's super complex. It is referenced in 2307 as amended today, and because it is one of the most popular things to be talked about. In addition to being addressed in 2307 as a vested right in zoning, it is itself a vested right in zoning as well. As I said before, estoppel doesn't apply, generally speaking, to governments when they act in a governmental capacity. That's a tried and true citation in the common law. There's lots of case authority. That well-settled rule was not eliminated by 2311C, but an exception was created. And the breadth of that exception has been the subject of a lot of debate, a lot of litigation ever since. And there have been subsequent amendments, for example, one in 2012, that really have further muddied the waters of what that means. And like I said, the 2311C exception is even more important because the seventh saga that was created in 15.2-2307 to create a vested right is itself referring to 2311C. So you have to comply with everything in 2307 and everything in 2311C in order to have a zoning administrator action serve as your saga. One of the things that is important to note is when you're talking about 2311C, it estops that official that has acted in that way. It doesn't estop the Planning Commission or any other body or person. The James versus City of Falls Church case in 2010 applied that. Here's the text of 2311C. The original text is shown on your screen. The 2012 amendment struck this words other non-discretionary at the bottom, and we'll discuss that in a minute. So what is an otherwise impermissible use? 2311C, Goyanaga, which is a Supreme Court case in 2008, and Norfolk 102 in 2013, says it could vest rights under certain circumstances to an otherwise impermissible use of the property. Now, what does that mean? I think that that means that it's what the zoning administrators interpreted the zoning ordinance to mean. And I think that that's logical. It certainly is consistent with all of the case law I'm going to discuss in a minute, and I'll explain that further. By its proper application, 15.22311C vests rights where reasonable persons may differ as to the meaning of the ordinance, and not where the zoning administrator simply erred or acted outside of their authority and thus committed a void act. That's important because that's consistent not only with all of the case law regarding void ab initio, it's consistent with the Dillon rule, it's consistent with 2307 case law that talks about vested rights only being obtained in a permissible use. The Supreme Court has not yet considered a case in which it vested an illegal use under the zoning ordinance. Just because of this 2311C provision and exception, and not because of the language in Goyanaga. And the Supreme Court should not, in fact, grant vested rights in an illegal use. Why? Well, there are serious problems. First of all, can a property owner vest rights in something that is impermissible? I mean, they simply don't have that right. Can a zoning ordinance violation, which is a misdemeanor in many localities, can a criminal act vest rights? I think that's a fundamental problem. It's inconsistent with the Dillon rule. It's inconsistent with the void ab initio doctrine. Now, who's estopped? Who does it apply to? If 2311C applies, it plainly binds the zoning administrator. But can an erroneous interpretation somehow vest a right in an illegal use against the governing body? For example, can it stop a court from enforcing the law, which has independent statutory authority to issue an injunction for violation of laws? Such an interpretation to vest rights under 2311C in an illegal use would violate all of those principles. What is a written order requirement decision determination? I'm going to skip over that, pretty much self-explanatory. It has to be actually written. I think significantly regarding 2311C, I think it has to be a valid written order decision determination. What has materially changed their position? That's other language from the statute. Well, that's a standard requirement for estoppel in general under the common law. It has never been applied by the Supreme Court, but presumably things like entering into contracts, expenditure of substantial sums, etc. Importantly, it has to happen after the saga. You can only materially change your position in reliance on the action of the zoning administrator after that zoning administrator or that saga has occurred. And so the timing is very important. And I think it's important to read the language in Goyanaga, in which the claimant sought the right to demolish a non-conforming structure and rebuild an entirely new structure, which is plainly not allowed under 2307 as a non-conforming use, the local ordinance, or the wealth of case law. And also importantly, as a matter of fact, in the facts of Goyanaga, that demolishing of that entire structure and rebuilding the new structure was not authorized by the zoning administrator in that case. Goyanaga was decided really on the reliance point, and the Supreme Court said the Goyanagas could not rely in good faith on the zoning administrator's approval, because the zoning administrator's approval did not approve the demolishing of the entire structure. And that really was the factual basis of that. And needing reliance and not having reliance, the Goyanagas lost. As far as I'm concerned, that's really what Goyanaga says and what it stands for. Anything really outside of that is dicta. And it's certainly very interesting to read, but it's really not applied in that case. Norfolk 102 had a similar kind of holding. Goyanaga established a requirement, I think likely springing from the reliance requirement, that the zoning administrator would have known he authorized a use not permitted, and introduced the require of a waiver. Waiver is, of course, something that under Virginia law is very difficult to prove. Waiver is an intentional relinquishment of a known right. It must be voluntary. You can't do it by mistake. You have to, a person trying to prove waiver has to actually show that the person knows the facts that are basic to the exercise of the right and the intent to relinquish that right, which certainly could not be true in the case of a zoning administrator error or mistake. And by using the term waiver and requiring that they essentially ignore the meaning of a zoning ordinance, they substantially restricted the ability of claimants to prevail. Gross negligence is not enough. It has to really be an intentional waiver. There are three major statutory exceptions to the application of 2311C. They've never been applied in court because nobody's ever found 2311C to apply in the Supreme Court. Malfeasance, fraud, and clerical errors, other non-discretionary errors, was deleted in 2012. Malfeasance is an act which is wrongful in itself, performed under the exercise of the office. Criminal intent also likely required, because malfeasance is the word used to define the crime. Misfeasance is different. It's basically the improper performance of some act which a person may lawfully do. Fraud is not defined, but that's essentially common law fraud. Fraud is very difficult to prove, even more difficult to prove than some of these other things. You've got to have clear and convincing evidence. It has to be actual fraud, a false representation of a material fact with an intent to mislead. That's very difficult to prove. What is a clerical error, and what does it mean when the Supreme Court, the General Assembly struck non-discretionary in 2012? Before 2012, at least one circuit court in Fairfax held that whether it was non-discretionary or discretionary was really the first step in the analysis. And if you find that it was a discretionary versus non-discretionary, that sort of resolves the case. But the effect on the 2012 is simply not, change has not been addressed by the Supreme Court. Well, plainly a clerical error encompasses the obvious scrivener error, like I'm copying from one place into the other. It plainly does that. But it's important to understand that that's not the sole and total definition of clerical error under Virginia law. Certainly, the Attorney General has said that the clerical error is an error made in copying and writing. But it means something a lot more. It can mean an error committed by a clerk or a subordinate agent in the performance of clerical work, but it also denotes negligence or carelessness, which is not attributable to the exercise of some sort of discretion. Well, given the fact that, and City of Covenant cites that, and in that in that case, the building permit was approved in error in reliance upon an erroneous zoning line on the map. My question is this: there's a lot of cases out there that say that since a zoning administrator or local government official had no power or authority to change the law. They had no discretion to act. And if the touchstone of clerical error is a subordinate agent that acts without discretion, then in fact, zoning administrators may be clerks under that definition. There's no case law on that, but that's certainly, I think, a fair argument. The old void ab initio cases, Segaloff versus Newport News, WAE&V versus Hoff, Hurt versus Caldwell, are still good law, except it's clearly and plainly revised by the statute. Now, these cases have been cited by the Virginia Supreme Court after the adoption of 2311C and its precursor in 15.1. The principle on which they were decided, the void ab initio doctrine, is still good law, and it's been cited time and time again. Just recently, the other day, the Supreme Court issued the case of EMAC LLC versus County of Hanover, brand new case off the presses on Friday. In that, they cited the void ab initio doctrine to hold that a government action was in fact void. This is a doctrine that's alive and well. It makes no sense that the Supreme Court would not apply it in this case as well. It applies in procurement, it applies in lots of other areas. It's basically a result of the Dillon rule, which is alive and well. If a government official acts outside of what they are authorized to do, what they've done is null and void. The Supreme Court has yet to apply a 2311C vesting in a void ab initio scenario. So we don't really know exactly how that would be applied. Now, the Goyanaga case involved a valid authorized act, not a void ab initio act. And the act, which was approval of the plan, simply did not say what the landowners wanted to say, which was, hey, you can tear down all the walls. And the Supreme Court did talk about a waiver, but that was really indicative because the facts of that case did not involve a void act or an act outside of their authority. It did not involve an actual waiver of any kind. So we're not exactly sure how a void ab initio waiver would actually occur. Okay, post codification, I'm going to talk now about some of the cases that were decided in brief over the next number of years and hope to discuss sort of at the end some of the current problems and issues that are confronting local government officials and the courts in this. The Herbert case and the Hale case are very interesting, and I think that they are sort of indicative of both the high point in landowner vested rights and I think more closely where we are now. In Herbert, ex-rel Suffolk, there was a 4-3 majority that said rezoning with an accompanying land use plan that showed sort of the general land uses in those areas vested those land uses and those locations in the property owner. Now, significantly, that was significantly opposed by a strong dissent, which is written by Justice Kuntz, who later, interesting, wrote the majority opinion in Hale. And that dissent basically said, you don't have a significant affirmative governmental approval that actually vests any kind of specific project. You have general land uses, that's not good enough. Now in Herbert, the majority said it was good enough, but I will say not a single one of those 4 justices is currently on the court. And so that's why I say that Herbert really needs to be interpreted by its facts, and I think it's the high water mark of vesting. In Hale, there was a rezoning with an accompanying land use plan, just as in Herbert, but it did lack land use locations. And Justice Kuntz went on to write that opinion, and he also applied the statutory definitions, which now they could do, as to what does it mean to specify use, and what is a specific project. And in that case, they had not actually proffered a specific use. They had not actually proffered a specific project that had to be built as far as what exactly the buildings looked like. Despite the fact in that case, there was staff requests to do so. At that time, the developer said, well, but we want to keep our flexibility. And the Supreme Court, in Justice Kuntz's opinion, said flexibility is the opposite of specificity, which is the key to vested rights. And there were some specific arguments that the court rejected. In Hale, the rule was laid down for what rights vest. Sometimes local government officials will be confronted with a vested right claim, and it appears that they do have rights that vest, but then the question becomes, what rights do vest? There was an argument early on in the common law vested rights era that what rights vest is sort of a snapshot of the zoning ordinance. When I vest rights, I vest all the rights I could have under the zoning ordinances as of that day. The Supreme Court has said, no, that's not the case. What rights vest are those that are the result of the significant affirmative governmental act. And so the rights that vest are only those that the government affirmatively acts upon. And the evidence to support that claim to those rights has to be clear, express, and unambiguous. And so the Hale Court rejected the idea that vesting extends to every use of the land that was permissible at the time of the act. So, to use an example, let's say that there was a vested right in a subdivision plat. That subdivision plat was relied upon. Let's assume that all the requirements in 2307 have been met and there is a vested right. Well, what rights vest? Well, plainly the rights vest to the lots that are shown on the plat. Anything else that actually was acted on by the government in that plat that was required by the government to be acted upon in that. Does it vest the land uses? No, there's nothing in a subdivision plat that shows land uses. And so you could say, well, but it's a residential subdivision. Plainly, it's a residential subdivision. Well, maybe so, but that wasn't acted upon by that approval. And I think that's a very important point that needs to be applied across the state under the Hale rule. Under the conditional zoning statutes, there's an additional kind of vesting I'll mention real briefly called Quillen vesting. It was applied and argued in Hale. It wasn't successful because Quillen vesting relies upon an actual dedication of property. And in the conditional zoning in Hale, there was a promise to let the public use a bicycle trail across the property. This is a very popular bike ped path that goes through the town of Blacksburg. But there was never a grant of an easement. There was not a dedication of property. And so that Quillen investment failed. Greengale came out of my old stomping grounds of Culpeper. And there were 3 specific holdings in that that you can see on your screen. I really don't have time to go into that. I'll talk about Goyanaga a little bit more. 2307 vesting applied, did not apply there under 2307 because the building permit approval and the zoning administrator's subsequent determination that the demolition of the structure to its foundation violated the ordinance and resulted in the loss of the property's non-conforming status did not rise from a subsequent amendment to the zoning ordinance. There wasn't a change in the law. And so there simply was nothing for 2307 to apply to. Then they said, well, but wait, I've got a vested right under 2311C. And the Supreme Court said no. Why? Because the Goyanagas did not meet their burden of proof to establish that they could have reasonably relied on the zoning administrator's approval of the building plans. Why is that? Because the zoning administrator validly approved plans that showed removal of some of the walls, not all of them. So the facts just simply didn't apply to allow them to reasonably rely on that plan to tear down all the walls and then claim it was still a non-conforming use. In Crucible, the Supreme Court addressed the issue of whether the owner of property zoned for agriculture acquired a vested right to use its property to operate a security training facility, basically a military training facility, after obtaining a zoning verification letter from the zoning administrator that confirmed that the proposed use would be classified as a school under the current ordinance by right. The zoning administrator was responding to the Crucible's request for a zoning verification that this combat training, firearm training, surveillance detective education area was a school. The definition of school in the zoning ordinance in Stafford at the time was quite broad, and the zoning administrator's letter said, yes, it would be considered. Importantly, the zoning administrator said, well, the verification is valid as of the date of the letter, and it's subject to change. I think that's something that every zoning administrator ought to put in their letter because, in fact, I think that's something that the Supreme Court relied upon in that case. They went ahead and purchased the property. They argued they relied upon the letter. The question was it a significant affirmative governmental approval? Well, Crucible said, well, it's not one of the 6 things that are actually in the statute, but it's a catch-all. It's in the without limitation language at the beginning. But the Supreme Court disagreed and reiterated the common law rule, which is the A rule. There's no vested right in the continuation of the land's existing zoning status. And they said, we're not going to adopt a brand new saga by common law. It's up to the General Assembly to amend it. And I would say that unless you can find a significant affirmative governmental approval under the existing case law or under the statute, you're going to have a very hard time arguing some new saga. The Crucible Court said if there was such a beast, it would have to be of the same specificity and the same order of everything else that's in there. In other words, not a comp plan amendment, not anything else that that people have come forward ever since. Okay. In 2010, the Supreme Court, the General Assembly enacted House Bill 1250 to actually include some zoning administrator actions as a new saga. Now, certainly this was in response to Crucible, but it did not act to vest rights in a way that really would have helped the Crucible folks out under the facts there. It was a priority of the home builders, and it added a 7th enumerated classification to the list. And here's the text of it. The zoning administrator or other administrative officer has written a written order, requirement decision determination. That's an order requirement decision determination using the same wording and phrase found elsewhere in 2311. I sometimes call that an ORD for the order requirement decision determination regarding the permissibility of a specific use or density of the landowner's property that's no longer subject to appeal and not subject to change, modification, or reversal under 2311C, which we addressed earlier. Going through this very quickly, it may appear on its face to open the door broadly to vest rights based upon a zoning administrator determination. This is simply not the case. Why is that? There are many limitations in the statute itself that prevent a zoning administrator's determination from becoming a saga, a significant affirmative governmental act, or that lead to a vested right under 2307. First of all of the opening paragraph in 2307 still applies. You still have to have the saga, you have to have good faith reliance, you have to incur extensive obligations or expenses, you have to have reliance. All of those things still apply. And although the statute does hold the possibility there could be other unenumerated acts, so the Supreme Court has been reluctant to extend it, like I said before. As confirmed in subsequent cases, the burden of proof lies on the claimant to prove the vested right by clear, express, and unambiguous evidence. And there's no burden on the locality. If there's any kind of ambiguity or lack of evidence, then localities and the courts should apply that against the existence of a vested right. Here's the language. I'll go through it very quickly. First of all, the saga, the 7th saga, has to be the zoning administrator or other administrative official. Who is that? Well, it has to be the zoning administrator or an authorized administrative officer to do that act, to do that interpretation. Take a look at 2286A4 that talks about the zoning administrator that has authority to act on behalf of the governing body. Where is that? Well, that's found in the ordinance that authorizes him. Take a look at what your local government policies are. What does the job description say? All of those things are important factual questions as to whether they are authorized to do it. From time to time, I've had folks try to argue to me, well, I've got a letter from the county attorney. I've got a letter from the county administrator. Are they really administering the zoning ordinance? Are they authorized to administer the zoning ordinance? Not under 2286. Who is authorized? The zoning administrator or some other person that's authorized to act as the zoning administrator in that case. It's important that 2311C has the same language for ORD as in 2311A. And so therefore 2311A, old case law, is helpful to interpret this. But the same thing works the other way. 2311C case law applies also under A. It has to be a written determination. It has to be an ORD. Again, look under the case law for C to determine what it means under A, and A to see what it means under C. There's been a lot of case law under C that says that is not an order requirement decision determination. And so that does in fact limit this significantly. It has to be a specific use or density. What does that mean? I believe what specific use or density means is pretty self-explanatory. To the extent you want case law support, the Hale case talks about specificity and how important that is. Official determinations also have to explain the basis for the decision. There's a lot of case law I've cited here. It has to explain why it happened. You can't just have a yes or no and have that say, well, see, that's something I'm relying upon. Now, of course, in Lilly, there wasn't substantial detail, but there was an explanation of the zoning administrator's determination. They have to have finality and specificity. It can't just be a mere interpretation. The James case applied that. Localities can determine where the line should be drawn between opinions that are merely advisory and ones that trigger the requirement to appeal under 2311A and could be a potential saga under 2311C and 2307. I've advised localities to make a policy, stick with it, put the what the zoning administrator is authorized to do and not do into the job description. Advise in writing when you talk to landowners. Is this an ORD or is this not an ORD? Local governments have the ability to actually authorize and not authorize and to define for themselves. My advice to local governments is be deliberate about these things and make good choices and then communicate that clearly. There have been a lot of applications of the ORD requirement. As I said earlier, the Supreme Court has never found one of these things. And so, you know, it's kind of hard to say what one would be. We know one isn't. Goyanaga was not an order requirement decision determination that actually authorized the act in that case. An interpretation by the zoning administrator was a mere interpretation in the James case. It was not an ORD. In Norfolk 102, the zoning clearance certificate for business license purposes was not a specific ORD that the owners could have used to rely upon. The McQueen case had a compliance letter that was very similar to some of these earlier verification letters that did not actually specifically approve that project. What is a specific use or density? Again, I think Hale and Herbert probably are helpful, particularly Hale as the most recent case on that. It says the landowner's property. What does that mean? I think it means what it says. It has to be the landowner. The Long Lane case specifically held that a landowner may only acquire vested rights in his own property. So you can't vest rights in something that's owned by somebody else. Question, can a contract owner or a person aggrieved you know, appeal a vested rights determination, assuming they even have standing to appeal that? Can they actually claim a vested right? Not under this language. They're not a landowner by the plain meaning of the language. It has to be no longer subject to appeal. What does that mean? Well, logically, it has to have been appealable at one time in order to be a saga, and then it has to be no longer subject to that appeal. To be appealable, it has to have a person aggrieved under 2311A. If a claimant who has received a zoning administrator determination in their favor is not aggrieved, query, how can they then say that it's no longer subject to appeal because it wasn't appealable by them in the first place? That's an interesting point of law that we have yet to see the courts apply. Recent Supreme Court cases have narrowed what it means to be aggrieved. Friends of the Rappahannock versus Caroline County, this firm litigated that and said that the neighbors were not aggrieved under those facts as alleged. Bottom line, confirming a whole series of case law going back several decades that said it is very important to know that these people, in order to be aggrieved, have to have specific rights that are being impacted. They have to allege those interests, and they actually have to exist. They have to allege it, and they have to prove it. Deerfield versus City of Hampton was one of my Supreme Court cases. And in that case, the Supreme Court held that the limited purpose entity under the city charter in that case had no standing once its purpose, again, the Dillon Rule authority to act, ended. But most obviously, what does it mean to be no longer subject to appeal? It means that the 30 days have expired. The statute says that the 30 days only runs if there's a written determination that has given the warning of the appeal rights. If you don't give that, the 30 days doesn't run. Therefore, it can be no longer, it can't meet the requirement of no longer subject to appeal. If the 30-day window hasn't expired, arguably, and I think inevitably, I think that 30 days hasn't expired. The word and means that it has to be both, no longer subject to appeal, and it has to be no longer change, modification, or reversal under 2311. We've already addressed 2311C. I won't go over that again, but again, I think it's a very narrow exception. What happened in 2012 when they deleted non-discretionary errors from 2311C? I mentioned that earlier, and I think that is a very interesting case. We have not seen a case that has interpreted what that means. We don't really know because the Supreme Court has never addressed it. Now, developers have argued that what it means is, well, what that plainly meant is that overruled WAB versus Hoff and Segalov and Hurt versus Caldwell, all those no estoppel for governmental acts cases. But to be fair, the developers' attorneys also said that when 2311C was first adopted in 1995. And so, was that language determinative or not? Their argument hasn't changed. The language has. The question is, would the Supreme Court see that it changed? I would say that the Supreme Court has never held that vested rights occur in an illegal use. And they cited Segalov as recently as the 2008 case of Goyanaga. The court has only said that an otherwise impermissible use. And what is an otherwise impermissible use? The impermissible use is as permitted in the zoning ordinance as interpreted by the zoning administrator. That's what it means, especially in the case of a 2311C where the zoning administrator formerly said that it meant one thing. Now he says it means this. And so you're vesting rights in a use that currently, as interpreted by the zoning administrator, is impermissible. And so I think that's what it means. So what does it mean to say or other non-discretionary? What does it mean to strike it? I think that was legally surplusage. I don't think it was necessary when it was put into the statute originally, because the zoning administrator cannot amend the zoning ordinance, and they cannot make a decision that's inconsistent with the zoning ordinance. If they do, it's void. It's void ab initio. And how can a void act vest rights? How can you have a valid order requirement decision determination in a void act? How can you have a waiver, which I've discussed earlier, how difficult it is to prove that? How can you prove a valid waiver in a void act? But like I said, the Supreme Court has yet to uphold an estoppel under 2311C and has yet to apply these principles. So, we really just don't know. In the last several years, there have been several other cases: Leesburg versus Long Lane, Norfolk 102, Board of Supervisors versus McQueen. These cases have largely reapplied existing principles I've already discussed, so I won't spend a lot of time, and I'll open this to questions. Leesburg answered one interesting question, well, a couple of interesting questions, and one is, can you vest rights against a neighbor's rezoning? Answer, no. Can you vest rights in a proffer, and if so, to what extent? You can't, because a proffer is subject to later amendment. You have to prove it otherwise. Can an owner in only part of the property prevent an amendment of the proffers through a vested right theory? No. You as an owner have the right to amend your law. Going through Long Lane very quickly here. I apologize for the speed. So the major points, just to sum up: a landowner who owns a piece of a larger tract that's been rezoned subject to proffers can amend the proffers. The vested rights that can be obtained only apply to that landowner's own property and not anything else. Vested rights can't be held in a proffer, only in a land use subject to the saga, and that was based strictly on the statutory language. And I think that's a key principle in applying any vested right, is what does the statute say? Because it's a statutory exception. And also, vested rights cannot prevent a rezoning. It just says if you get vested rights, you can continue that specific use or that specific project as delineated by the statute and the significant affirmative governmental approval. You cannot just prevent a rezoning. Governing bodies have power and legislative discretion, and the vested rights principles do not stop that. Norfolk 102 is some unique and odd facts, but the bottom line is it's very similar in some ways to Crucible, in that there was something that was not an order requirement, decision determination. It essentially involved it cited Goyanaga for the permissible use can be a subject of a vested right. It also said that it applied case law to the 2311C and said estoppel under 2311C requires a specific determination to allow a use that is now impermissible under the zoning ordinance as applied. In that case, the law hadn't changed and his interpretation hadn't changed. And so the cash receipt was not a specific interpretation that could be done. 2311C, here are some of the principles. Zoning administrator actually didn't say something contrary to the ordinances. He did not issue a formal zoning determination. It was really just a scrap of paper for purposes of business license application. And again, found no estoppel. McQueen is the latest case to find no vested rights for the lack of a saga. The compliance letter was very similar to the verification letter in Crucible, and the same result occurred. Very similar to Norfolk 102 as well. So what's up next? Let me say a couple words about what issues are coming down, and then I'm going to open this up to questions. Hopefully you'll have some. What is diligent pursuit in a down economy? Is it similar to the Herbert case? What is diligent pursuit? A factual determination at circuit court is going to be critical to this, because if a circuit court finds that there was diligent pursuit based upon competent evidence, or found there was no diligent pursuit based on competent evidence, that's going to be very persuasive to the Supreme Court. Second, what else might be or not be an order requirement decision determination? So what do zoning administrators issue that is or is not an ORD? We're still fleshing that issue out. So far, the Supreme Court has been very clear about what is not an order requirement decision determination. They have not said really yet what is one, and they have never held that an ORD, that an invalid void act by a zoning administrator can be an ORD. And also, how specific must the project be in the saga? Sort of Hale versus Herbert. Hale said it has to be specific. Well, how specific is specific enough? And then, of course, like I said, what rights vest? Hale said it's actually approved, but we haven't really seen an application of that principle in specific cases like a variance. If you apply Hale strictly, all you really get vested in a variance is the variance of the setback or the height requirement, nothing else. I believe that's actually all that vests, but the Supreme Court really hasn't gotten to that. Will the Supreme Court really find an estoppel under the 2311C? They've never done that. Can a mere error or a void act be an ORD to vest rights? What exactly is a waiver? And can a void act be a waiver? I think a very important question, setting aside all of the issues I've talked about under ORDs and 2311C and vested rights, can a court or a governing body or even some other aggrieved person be estopped under 2311C? The James case said no as to a planning commission which had independent authority. Well, a court has independent authority to issue injunctions for legal violations. 2311C doesn't apply to courts. What about a governing body? 2311C doesn't say anything about them. They have the ability to bring actions and criminal warrants to enforce their zoning ordinance. 2311C doesn't apply to them either. But again, we have not seen a case other than the Planning Commission. And lastly, really, how does that interaction with 2311C and 2307 play out when the governing body acts to overturn its own zoning administrator? And what are substantial expenditures? It was briefed and it was an issue in Hale, but they really didn't get to that issue. So really, I'm open to questions. I have 7 minutes left. I was hoping to have more like 15. But if you have a question, I'd be very glad to hear them. Just type them in I guess the chat box on the right. I'd be happy to answer those questions. If you want to engage in sort of a discussion offline or outside of this event, here is my contact information. I'm always interested to assist local government attorneys and local governments in applying these issues properly and in defending local governments and local government zoning administrators against these types of claims. I believe strongly that these principles are very important exceptions to the common law principles, the ABCs, as I said at the beginning, but they're also narrow exceptions. And I think that my theory has been borne out in 20 years of case law since 1995, 1998, in which there's really been just one case, maybe not much more than that in the Supreme Court case that has actually found a vested right. And there's only been a handful of vested rights cases that have been upheld from the circuit courts in all of that time. So I believe that we see a lot of these claims. We don't see a lot of them upheld. And so if you have one of these cases and you're interested in prevailing in them, I'd be glad to hear from you. And certainly I'm a big believer that what you see in local government is preventative lawyering is much cheaper and less expensive and wiser than waiting until the case arrives and then you have to litigate it. I'm very happy to litigate for you. I just don't think that that's probably the wisest course. It's really best to hire me early or hire other competent counsel early. And at that point in time, guide the decision-making process so that you can actually fall on the right side of some of these principles I've discussed today. So questions or comments other than the original question about what is estoppel? Any questions or comments?
I just wanted to, if my takeaway were right for the day, I think that hire a lawyer. If you're an applicant, you want to get it in writing and do it early. Then the question is, what is it, right?
Well, it's purely statutory, like I said, and so you have to go through it. I mean, it was kind of painful, I know, for many of you to hear me go through each of those terms and apply them sort of in specific order out of that statute, but that's how the courts do it. And so it's very important to apply each one. And so, I agree. I mean, you have to figure out, is it an ORD first before you get to do a lot of those other things. And so let me see, or maybe you'd like to see me. Is that a possibility here?
Yeah.
Okay, let me see here. Can you see me yet? How's that? Okay, I'm back. Hi, everybody.
The key there is trying to seek to be specific in your application.
Well, absolutely. I think local governments have to be very careful whenever they're acting to interpret the law and to be very clear about what they do.
On the other side, if you're like the protection in a way to not be specific, so you don't show invested or maybe you should have. Of course, the idea here that the illegal somebody with an illegal act is again not permissible at all. You're looking for things specific.
Well, specificity is certainly the key in vested rights, and it's both on the front end to sort of get vested rights under 2307, but it also is important on the back end because it's the specific approval that defines what the vested right is. And so really specificity of use and the specific project are important principles in vested rights, both coming and going. And as the Supreme Court said in Hale, flexibility is the opposite of specificity. So if you are a landowner and you're pursuing flexibility, which landowners often do for good economic reasons, they need to weigh very carefully what is the result of flexibility because that may in fact prevent their vested right, as it did in Hale.
And the other thing I had from your presentation was the idea of creating within the commission for say zoning administration to do further description. Is there any guidance? Is there something that's out there already?
I'm sorry, you were breaking up a little, Jonah, and I had a hard time understanding you. So.
All right. Again, is there the idea that there's available?
Oh, is there a policy available to assist local governments in sort of deciding what is an ORD or not an ORD?
Well, the idea of stating things for a zoning administrator's job description.
Oh, right. Well, I think that that's important. Obviously, I think that might make zoning administrators a little uncomfortable because you obviously don't want to act outside of your, your job description. But I think that's an inevitable part of all of this, because it arises in several contexts. Who is a zoning administrator or other administrator who's authorized to interpret or enforce the zoning ordinance? I think the local government needs to be deliberate about that. Who is and who is not those people? And so a local government has the power to sort of delineate that, and thus, certainly legally reduce the scope of potential vested rights. It also, on the other side, is once that's been defined, an exception to a 2311C estoppel and 2311C vested right is in fact malfeasance. I mean, if you've actually acted without authority, and that's different from acting wrongly within your authority, which is a misfeasance. If you've actually exercised malfeasance, it's outside of your authority. And so I think that it's very, very important. Now, again, I know zoning administrators may be uncomfortable, but that nobody wants to be accused of committing malfeasance. I think that ultimately they can rest a little bit assured, because I think criminal intent is required to actually prosecute for that. And I don't know of any zoning administrator that would ever have that type of evidence brought against them.
Or the idea of administrators being clerks, as you kind of illustrated.
Let's see, there's a question on the screen here. A proffer, you mentioned a proffer cannot be vested. Does that include proffers at state? Go back to the Long Lane case on that, Mr. or Mrs. Blackburn. I would say that the Long Lane case applied proffers in really all of that. The proffer in that case was a specific use. It was actually a roadway that was shown, and a specific required infrastructure improvement, and that was actually proffered. And Supreme Court gave lots of reasons why it was not a vested right. One is you can't claim a vested right in somebody else's property, but they also said, I'm sorry, the local legislature, the local board of supervisors or town or city council has authority to amend those proffers. It's a legislative act, and you can't stop them from doing it. All you can vest rights in is the specific use or specific project, specific approval of the saga. It's all you can achieve vested rights in. You can't achieve vested rights in the proffer in general. So hopefully that answered the question. Well, it is 1 o'clock.
Yeah, absolutely. Unless there's any other questions from the chat box, which I don't see any. I just want to thank you very much, Andrew, for your presentation. Of course, this is but one of the presentations we'll be giving through the webinar series. Hopefully folks know to join us. We're going to be talking about BZA law, and Andrew's going to be joining us for that conversation as well. Of course, you can go to planvirginia.com to register for that webinar and any of our other upcoming events. Andrew, thank you so much again. Really appreciate your time today, and look forward to having you join us next time.
All right. Thank you, gentlemen. Thank you all for being here. Appreciate it. Thank you.
Absolutely. Folks, if you need to watch this video again, I know I will, because there's a lot here. You can always find that on our YouTube page. If you go to Plan Virginia, those videos will show up there as well in our media section. But yeah, find us Plan Virginia on YouTube. You can always watch this stuff again. Thanks, and take care.